it's a betrayal of public trust. That is just not ethical.
I left the Democratic Party because of her.
The reason is because you're taking Republican money.
The money of those people that pay me as a consultant. What are you taking? What did you take in Crosstown? Took money. I saw it and I saw them pay you checks.
Okay, hold on. Everybody. And we're back after a brief break. You're watching Attorney Joe Flores, your host of South Texas Crossfire. Special thanks to the Lopez family and my good friend Carlos Lopez, the Ted Turner of South Texas Broadcasting, right here on KTMB Channel 6, the only station with political teeth. And we advise everyone out there in political season, invest in KTMB by calling Ted Turner personally. Carlos Lopez, 904-1762, 904-1762. Special thanks to our sponsors you saw on the break, River City Hospice, Hope, Dignity, and Love. It's got to be hospice, Alzheimer's, cardiac problems, lung problems, neurological problems. You can call strokes. Let me tell you, hospice is a great thing that we can help people out with. Call, it's not what you think, and that is hospice, 882-5900, and also Vasquez Flores Home Health. Vasquez Flores Home Health, backed by over 20 years of experience. Priscilla Vasquez, RN, can help you get a provider and prevent long-term care from happening. If at all possible, call Priscilla today, 881-9922, or if you're interested in a job helping people, 881-9922. So let's get back into it feet first. We are talking about the federal system, incarceration. We have more people incarcerated than most anybody, any country in the world. And we're trying to find solutions to that. But in the federal system, a lot of people don't have enough knowledge about it. So who better to call than a colleague of mine who's in trial work every single day in federal court, and that's Juan Reyna, and you can call him at 993-8100. Juan Reyna's here with us. Welcome back, Juan. How are you?
Very good to be back, Joe.
Okay. Now, Juan, we were using some examples. Human trafficking. You said, and this is confirmed, that human trafficking is almost vying with drug trafficking as becoming one of the biggest industries for organized crime, not just for Mexico, but around the world. You've dealt with people that are gang members. You've dealt with people that are innocents that have been pulled over. You've dealt with all kinds of trial work. Let's jump into it. You talked about the arraignment process. Let's use our example that we did before the break. Innocent man gets caught with 50 pounds of marijuana in his truck, doesn't know where they came from, and then he's taken to the station. Homeland comes, he's arrested, he's taken to a detention center somewhere, and then he's arraigned, told of, let's start with bond. Is he eligible for bond? You're called into the case, the family hires you. What happens next?
Well, bond, it just depends on the quantity of drugs involved. Once you get to a certain level, there is a rebuttable presumption that bond should not be given. It's quite astonishing because, of course, we know that bond should not be punitive in any way. The whole thing about posting bond is just to assure that you're going to be able to comply with all the pretrial conditions as set forth by the court. The biggest one, of course, is that you're going to attend any future court hearing. But there is a rebuttable presumption depending on the amount of drugs confiscated. That, coupled with the individual's criminal history in the federal system, will very much determine whether or not pretrial services will make a recommendation for that individual to get bond, and will very much guide the discretion of the magistrate judge about whether or not to approve a bond or not.
And let me stop you there. A lot of people that have called me on federal cases say, I called a bonding company, right, and they say they can't get my husband out, and they're desperate. And I say, in the federal system, big difference. You don't have bonding companies going in there and taking people out. It's right. Pretrial services that handles everything.
That's right. And in many respects, the system's a little bit fairer or a lot fairer to a family. So for instance, in the state system, you might, let's say, have be accused of a serious offense, and perhaps there's a $50,000 bond. Typically, then a family would go to a bonding company, and there's nothing inappropriate with what the bonding companies charge.
No.
Typically, it's 10%, and that's fine. But what ends up happening is the bonding company, of course, will keep that as their consideration for helping ensure that the person goes to court when they're supposed to go to court and everything else, but there's no refund of the money. In the federal system, it's just the opposite. The court may impose a $50,000 surety bond with so much cash up front, maybe $2,500 or maybe $5,000. But provided that that individual complies with all the terms and conditions of his bond, at the end of that person's case, whether that person is found to be acquitted, found not guilty, and the case ends, or if the charges are dismissed, or if the person's found guilty and is going to be incarcerated, at the end of the case, whoever posted that bond will get that money back. And so in many respects, it's a little bit fairer.
So you're at the bond hearing. You explain to the judge, look, this guy has close ties with the community. He's with the Kiwanis, for goodness sake. He's got a wife, children, never been in trouble before. Pretrial Services makes a report, don't they?
They do.
And it says, this guy's eligible for bond. We recommend this.
That's right.
Right? So you spring him, you get bond, they pay. The Pretrial Services, they work with him. They go home. What's next after the detention hearing?
Well, what's after next is, in your instance or the fact pattern that you just gave, the person gets arrested. They'll go in for what we call the preliminary detention hearing. The purpose of the preliminary hearing is to determine whether or not there was probable cause to believe that a crime was committed. And so you're entitled to cross-examine the government's witnesses or the government's case agent in order to demonstrate to the court that perhaps there is no probable cause to believe that a federal crime was committed, and then the case kind of goes away.
He didn't know that the marijuana was in the trunk in our example.
That's right. Now, but that's a dispositive issue that's not going to have a bearing
on the bond.
On the bond or on the preliminary.
Exactly.
If a person is at a checkpoint and there's contraband or in our instant case
50 pounds of marijuana.
50 pounds of marijuana, no, the judge is going to find that there's probable cause.
It just aliens didn't just put it in the trunk.
Right. I mean, 99% chance, I would think the government, the court or the judge would find that there was probable cause. A bond's given, and about probably 2 weeks later, you'll be back in court again for what we call an arraignment, wherein you're formally apprised of the indictment that was been handed down by a federal grand jury. You'll enter your plea of not guilty. You'll be given an Ellis order and a scheduling order. Basically, what that order does, it sets forth certain deadlines that litigant and his or her attorney must comply with for filing any dispositive motions with the court. Those are motions to suppress or any discovery disputes that you're having with the government. You need to bring those pretty quickly to the court's attention. You can't wait to the very end.
And discovery is all the evidence that they have.
All the evidence that they have against you.
And you go down to the U.S. Attorney's Office, they don't let you make copies like they do in state court. You've got to go and review the stuff.
That's right. That's one of the big difference here. It makes it tough for the defense lawyer to do their job, but that's one of the big differences. In state, they'll hand you a whole packet of all their evidence, and you can take it back in the luxury of your own office and review it and dissect it and figure out how you're going to attack it. In this federal system here, at least for the Southern District of Texas, which encompasses Houston all the way down to Brownsville, and then it dovetails west all the way to Laredo, all of that area encompasses the Southern District. Their policy is, no, you can come to our office, you can review their evidence, but and you can take as many notes as you want, or you can take your dictaphone and read every document into your dictaphone, but what you cannot do is they will not give you a copy of their documents.
Well, and we've got about 4 minutes left. This half hour has zoomed by.
Yes.
But let's do a little fact scenario. Our guy, the manager at JCPenney's, who said, I've never seen this 50 pounds, starts feeling the weight. You show him the discovery. You show that he didn't tell you something. What else is new? That he didn't tell his lawyer, all right, maybe I had told the arresting officer it's mine, and then I changed my mind, but the arresting officer put it down. You told him, which happens 9 out of 10 times, why didn't you tell me all this, right? So the guy says, okay, I was down on some money. I was going to get paid $1,000 to bring it over. I was just going to take it to Falfurrias, leave it off, and go back.
Well,
so now he's saying, I want to plead guilty. On our example, he doesn't want to go to trial. So what happens next? It's the rearrangement, right? The plea of guilty?
You go to a rearrangement. The judge will ask you, about almost an hour worth of questions to make sure that all the information is put down, and to make sure that the plea is taken voluntarily and freely and knowingly and willingly. Nobody's threatening or promising the person to enter a plea, that they're doing it of their own free will. And so the court will ask a variety of questions to get those type of responses to assure the court that, one, the person knows what they're doing, two, that this was their decision and no one else's, and three, that that they understand the consequences of their plea.
Yeah.
And so, in that instance that you just provided, yeah, sure. I mean, the evidence will very much dictate which way you take a case. In that instance, the only way to have knocked that type of evidence out would be file a motion to suppress that perhaps your client gave an involuntary statement against his will.
You should have suppressed his mouth with duct tape. He talked to sometimes they get nervous. Everybody says don't say anything to the police, but if you've never been put in handcuffs, if you've never had guns around you, you're being asked questions,
that all goes to the voluntariness of that statement. And what you got to keep in mind is, and I tell juries this all the time, look, I didn't create this system. I'm but a lawyer practicing law in 2012, practicing federal law, but this system was handed down by all these men who we were all taught to believe were the greatest Americans of all time. Whether their name was George Washington or Thomas Jefferson or Alexander Hamilton, these rights that we all have as Americans, the Fifth Amendment right to remain silent, this is a constitutional right. These are not punchlines. Your right to effective assistance of counsel, your right to confront those individuals who are bearing witness against you. You have an absolute right to challenge them. You have an absolute right to have your case heard by a jury of your peers. These are fundamental constitutional rights that we enjoy as Americans, and they're not trivial in any manner or any way. They are to be safeguarded, and I look at these cases very carefully in order to determine whether or not statements were voluntarily given. For those very reasons that you pointed out, people showing up with guns, and perhaps a little bit of double talk or exerting pressure, and oftentimes statements are not given voluntarily. In fact, there's a whole new science out there right now of people who have spent many, many, many years in prison who gave false confessions, but whose confessions were the basis of their conviction. And why would somebody confess to something they didn't do? Well, there's now a whole new body of literature regarding that issue. And so it's very much an issue that we focus very, very diligently on when we're looking into these cases.
Well, 30 seconds left, and it's been a pleasure having you. It's gone by very quickly. I hope you come back. But you're listening to Juan Reyna, 993-8100, a federal practitioner, the NFL of law practice. So 30 seconds left. What do you like to tell the audience about the federal system and what we talked about?
Well, it is just like you, Joe, it's a joy to be over there. It's a true privilege and honor. We, of course, hold the federal courts in the highest of regards. They are Article III constitutional courts. They are co-equal branches of government. There's no difference in terms of the power structure between our federal judiciary, our United States Congress, and the presidency. They're all co-equal branches. It is an awesome form of government. It works. And it's a true honor and privilege to be over there. And we like to believe that we make a difference. And it's been my experience through a whole lot of hard work and a little bit of luck that things tend to work out.
Juan Reyna's email is up there, but sometimes we put it on the radio. What's the best email for the people to shoot you an email right now or call?
Well, it's jr@jreynalawfirm.com.
That's jr@jreynalawfirm.com. That's appearing in front of you, 361-993-8100. If you have any federal questions, remember the show does not constitute legal advice. Please obtain the counsel of your choice or call the State Bar for more information on elite practitioners like Mr. Reyna who focus in on federal law. If you are worried about federal indictment or going down on some sort of count or have been caught in a web that involves conspiracy, now that's a whole new other program, and we hope Mr. Reyna will come on and we'll talk about in depth about conspiracy, commit crimes that you've been accused of, and how you can get caught in this web just by getting involved with bad guys, even collaterally. So it's been a pleasure having you, Mr. Reyna. Thank you for coming on again.
Appreciate it.
Yeah, and again, 993-8100 or jr@jreynalawfirm.com. Thank you, and God bless.
Have you been arrested or are potentially facing criminal charges? You need a trial attorney who is well-versed in the courtroom. Joe Flores has handled hundreds of criminal cases and many of them to trial. Joe Flores can provide you with competent representation to protect your constitutional rights in state and federal court. Joe Flores can help if you have been arrested or facing criminal charges. The law offices of Joe Flores, equal justice for all. Call River City Hospice for your loved one's care today. River City Hospice is a compassionate, patient-centered healthcare provider with a unique approach to medical care and support for people at the end of life and their families. River City Hospice focuses on maintaining dignity, increasing quality of life, and providing comfort and reducing pain due to illness. Hospice care allows your loved one to be treated with dignity and respect and gives them the right to choose. Call 882-5900 today. Hope, dignity, and love. It's got to be River City Hospice.
Hola, soy Joe Flores, abogado, pidiéndole a la comunidad hispana que se formen parte del Partido Demócrata. Los demócratas son conocidos como el Partido de Derechos Civiles y Derechos para todos los hispanos. Grupos como LULAC y el GI Forum iniciaron en Corpus Christi. Republicanos quieren quitarle derechos a niños y mujeres y programas importantes. Involúcrese, regístrese para votar y recuerde que el Partido Demócrata no es el partido del pobre, es el partido de justicia social para todos.